Good afternoon, everyone. I'm Gary Summers, and welcome to the audio edition of Mind, Body, Soul. Again, this week I have a very interesting guest. This is part one of two parts that we're going to do with a good friend of mine, lawyer Denis Barry, who's going to talk about wills, and the second one, which will air the following next week, will be about the Divorce Act. So, welcome, Denis Barry.
Thank you very much, Gary. Real pleasure to be here.
So, Denis, let's get in and talk about wills. Are they necessary?
Well, legally not necessary, but desirable and highly recommended to have one. Because a will is an expression, your expression about what you want to do with your estate when you die. And if you don't say it, then the law will tell you what happens, and that may not be what you want. If you die without a will, you die intestate. And that means that you're now going to be governed by a piece of legislation called the Intestate Succession Act. And that will tell you exactly what happens to your estate. If you die single, if you die just with a spouse, if you die with a spouse and one child, a spouse and a number of children, or you die with no spouse, no children, and how it goes. So there's really a formula that tells you how that estate is going to be dispersed. It may be that a lot of people don't care, and they say, that's fine, if that's the way it goes, it goes. But a will tells you exactly, you will tell your executor exactly how you want your estate to be distributed.
And you want control over that, obviously.
Clearly.
Okay, so next question is writing up your own will, pen and paper, just writing down what you want. The ones you buy off a shelf, do-it-yourself wills, you $10 or $50, whatever it is, or a lawyer. Advantages, disadvantages of each one of those.
Nothing inappropriate with any of them. Illegal, contrary to the Wills Act, which is the act that governs wills and the preparation of it. A will has to be reduced to writing, except in one particular case, which normally doesn't apply. So it has to be reduced to writing. And it has to abide by the rules set out in the Wills Act. This is a province that allows holograph wills, and holograph wills are wholly handwritten wills. So you can write down all your wishes, date it and sign it, and you don't have to have it witnessed. So as long as you identify it as a testamentary disposition, saying, look, this is my last will. I appoint Gary Summers my executor. I leave all my property to my loving sister, date it and sign it, perfectly valid. The one where you get off a computer, let's say, a template, where you essentially fill in the blanks.
Yeah.
Again, nothing inappropriate about it. But again, this now is formalized. Now you have to make sure you date it and sign it in front of two people who are present at the same time. So you can't sign it in front of the television one night, go into the next room and say, oh, by the way, I just signed my will. Can you witness it? That's an invalid witnessing, and it invalidates the will if it's going to be probated. Nothing wrong with it again, but the will that's prepared by a lawyer is done very specifically because that lawyer will ask questions that most people don't think about. And say, what if this happens? Oh, gee, I never thought about that. Then you think about it and give me so we can embed it in this will. And the other part of it is ambiguity. You and I know that people write things and they have it in their head that they've expressed themselves clearly, when in fact they're using words that can be used defined in a number of ways. So what do you mean by that? That kind of thing. So if you're going to prepare your will, make sure it's not vague or ambiguous. But you're much better off if you go to a lawyer.
Go to a lawyer, yeah. What's the difference between a will and a power of attorney?
Well, a will only speaks from death. So you can prepare a will today, 10 years down the road, decide that things not the same, you want to change your executor, want to change your guardian, or whatever. That document, the last will speaks. So if you have 10 wills in your lifetime, the last one speaks, provided the others have been revoked, which is the normal thing. I revoke all previous testamentary disposition will.
So you have to state that in the will. You
state, yeah, if you're revoking. If you're changing your will, you can do a codicil, or a number of codicils that changes people or changes locations or whatever you want. But so a will only speaks from death. A power of attorney ends at death. I will give you my ability to act for me. Okay, so Gary, you take my power of attorney.
When would you give someone your power of attorney?
You can do it now, just in case something does happen. You become infirm, physically infirm. Let's say you're in bed or you're in hospital, and you want someone to act for you to bank or to do certain things. Most times that's not particularly important because your wife or spouse or partner would have access to the accounts anyway, so they don't really need it. What's really important about a power of attorney are two things. One, a power of attorney in a normal sense, unless you identify it differently, ends if you should become legally incompetent. So if you become senile or comatose, you are legally incompetent. That power of attorney that I just gave you ends. If I say, though, Gary, I'm going to allow you to endure that legal incapacity, it becomes what they call an enduring power of attorney and allows you to act for me even though I'm comatose. So that's important. And a lot of people will say, I don't need one now, but I would like to have one should something like that happen. So that's what I find in my practice. I'm dealing more with that. And that legal incompetency has to be confirmed by a doctor. They'll have a letter saying, yes, this person is not able to look after themselves. The other important thing about a power of attorney is it replaces guardianship if you word it right, particularly in relation to real estate. So let's say a husband and wife give each other power of attorney. I will embed in that power of attorney the ability of one of them to sell their residence should they need to do it. Because if you're in hospital or you're comatose, you have no ability to convey your half interest in the property. So if your wife is home in a big house and you're going to be at the Miller Center, or you're going to be in a personal care home, and she doesn't need that house anymore, or vice versa, you don't need the house anymore, you have no capacity to sell her interest or his interest unless it's empowered in the power of attorney. And if you don't do that, now you're going to make application to a court to have the court you appointed as the guardian.
So power of attorney is different than the healthcare directive.
Healthcare directives are a simple document that where you say, should I be unable to tell my doctors how I wish to be treated, I'm going to appoint my wife or partner or my son, my alternate or substitute decision maker. And I'm going to empower that person to make that decision for me. And some of those, healthcare directives are very lengthy and others are very general. But hospitals will look for them. And they'll say, do you have, if you're comatose, you say your spouse, do you have an advanced healthcare directive?
So if something happened to me, say I was walked out and got hit by a car and I'm in a coma in the hospital. Mm-hmm. I don't have a healthcare directive for my wife. Mm-hmm. She can't make decisions?
No, she will. They'll be guided by her, but they're more confident. And now doctors, I can tell you, are not obliged to follow your directive. If your wife says, unplug him.
Sure.
Yeah. and the doctor say, no, he's fine.
Okay.
Okay. They can overrule her.
An executor of a will. Mm-hmm. Does every will have to have one? And what happens if you don't have an executor? And payment. Does an executor get paid for that?
You should name an executor. The executor is going to be your voice after you die, and with full empowerment to do what needs to be done to follow out your wishes. Okay? I advise people to appoint an executor and an alternative executor should the executor you name not be able or willing to act when you die.
Yeah.
But that will is not invalidated by the fact that you forgot to or did not name. Lots of people don't name executors, just never enters their head.
Right.
Then you go through a form of administration with the will annexed, CTA. And instead of an executor, you have an administrator cum testamento annexo, CTA. And that person is empowered to do the same thing as an executor. And you're talking about fees or whatever. Yeah. If it's specified in wills, and lots of wills through corporate people will specify the ability to charge a fee, there is no prohibition to imply that the person carrying out can charge a fee, but in most cases it's family related,
right.
And they don't do it.
Right.
Simple as that.
The purpose of a trustee and a guardian.
Well, a trustee is an executor is a trustee,
Okay.
and often in a will they'll say, "Hereafter, call my trustee."
Okay.
That's a will situation, but you can appoint someone to be your trustee. You can set up family trusts and things. Again, a function that person essentially operates your empire, your whatever. What was the other term?
Guardian.
A guardian is a person that, in law, is entitled to act as your overseer, decision maker. Parents are natural guardians.
Okay.
If in a will they say, look, should we die and we got 2 kids, they appoint a guardian.
Right.
Those people can act as guardians for the children.
Okay.
They look after things.
Probating a will. And can it be avoided? Because I've seen situations where wills are in probate for months and months and months.
Well, you can avoid probate in a number of ways if you're ahead of the game. So, like if you're dying and your biggest asset is your house, if you convey your house before you die, and that's your major asset, you can avoid probating the will because everything else would be done informally. Right. And if you can access, if there's a joint account, you can access it without probate. But if you die with a real property, and that's one of the major reasons why you would get probate a will, is to have someone formally appointed by the court, the person named. They get letters of probate and they are appointed the executor. That's proof to the world, banks, realtors, whoever, that you have the capacity to sell that house or access that RIF or access that RESP or whatever.
Okay, so if a mother living alone owns her house and passes on, the kids, and it's in her name, the kids just can't take the house and sell it.
They have to either, if she dies without a will, get an administrator appointed under the Intestate Succession Act, or follow the will and get an executor appointed, and that executor or administrator has the capacity the only person that has the capacity to sell that piece of real estate, not the kids.
So there is an advantage to gift your residence to your kids?
There is, yeah, because that is essentially, in most cases, the major asset of that person's estate. There may be money in an account. Well, usually the spouse is a joint account, so they can actually access that at or after death and move it. So there is a way to structure your estate where probate becomes unnecessary.
Contesting a will.
Yeah.
How is it done? And I from what I've read and the bit of research I did was many years ago, if a sibling contested a will, the fees were taken out of the estate. But now if a sibling contests a will, they have to actually pay for it themselves. Is that
not necessarily? Partially correct. You contest a will. In the process of probating a will, you have to post what they call a 5-day notice at the probate court, Supreme Court in Newfoundland. Most people don't know it exists. But it's a piece of paper that has to exist on that board for 5 days. If someone's going to contest a will on the basis of undue influence, fraud, whatever, they have to turn that around and put in a caveat. They have to put in a protest. Say, we protest this will. That's the first indication the court has that this will may be contested. So they won't grant the probate. They'll inform the applicant that we have a contested will here. We're going to have essentially a trial, a hearing.
So someone has to go down and check that board every day?
Every day. But see, people don't know that because, like 999 out of 1,000 wills will never be under any circumstances contested. Right. That one ends up in a trial, witnesses are called. My mother was senile. She was not in a position to consent to that will. Or she was unduly influenced, or he was unduly influenced, whatever. Whoever's alleging that has to prove it. Medically, they can't walk in and say, well, my mom couldn't read.
Right.
Okay, that kind of thing. And the judge will determine if it warrants, avoiding of the will.
I've read some situations where, that's a fairly expensive process that could take a week.
Oh, the trial itself could take longer.
Yeah.
But getting into court, Gary, is the biggest thing.
Sure.
Access to justice is more of a dream than a reality, because especially in Supreme Court, It's extremely, busy, one, and it has a process that you have to follow before you can get through the doors. And by the time you get through the doors, in most cases, you've spent a ton of money.
Yeah.
So when you're going to go to court, you better have a lot of money in your pocket, and you better make
good reason.
and you better have that sense you're going to win.
Do you include every single item in a will?
No.
Like pictures on the walls and...
Yeah. I often say, I said, I don't need you to tell me about an Aristotle Onassis will. Just tell me what you want to do with your property. Now, a lot of people will want things like a painting or an heirloom of that.
You put that in a will?
You can if you want to. What I advise people to do is I will say, and follow the directive attached here to us to the disposal of my personal property. And I make the beneficiaries, as part of the will, or the testator, say, okay, that picture goes to Denis, that picture goes to Gary, that tool goes, and they list it, and they'll stick that in with the will.
Okay.
That's the best way to deal with it. Now, some people will want it all in the will, and it's 14 pages of chisels and pictures and cars and stuff. You don't get that a lot, but what I always advise people do when they make a will, I never seal the will in an envelope. I'd say, you should put your banking information, where you invest, where you may have life insurance, in that so that the executor knows essentially where to find your estate. And the other thing you might want to do is put in something personal to your children or to your spouse that doesn't really belong in a will, but something that, like, I'm going to miss you, you're going to miss me, that kind of thing. Something personal. So I always encourage people to do that.
What's the biggest thing that could complicate a will?
Well, any will that's prepared where there's a contest about it, the beneficiaries say, well, no, Mom wasn't right when she did that will, or she told me differently. And then they protest it, and then ends up into a trial. But the other biggest thing is ambiguity. People use words, everyday words, not realizing what it means. I'll give you an example. Somebody says, I leave everything to my wife. Should she predecease me or die as a result of a common disaster, I leave everything to my children.
See, to me, that sounds fine, right?
I mean, that's
to
fine.
you, it doesn't.
Yeah, to me, it's not fine. It leads me to other. Well, what happens if one of your children dies before you, leaving a child or children? Do you want your grandchildren by that child to have their parents' share, that kind of thing? And what happens if they're young kids and you're going to Disney World and you all go?
Yeah.
And you got a common disaster thing.
Yeah.
So you just add sensible questions to it, right?
Would you include funeral arrangements in a will?
Not really, although I do always ask if there's a particular, do they wish to be cremated or wish to be buried, and if they wish to be cremated or buried, do they wish to be in a certain, cemetery? Some people say, no, leave that up to my executor, so you don't mention it, say, I'll just pay all just debts and funeral expenses. But then the other part of it is, I want to be cremated. So, okay, what do you want to do with your ashes? Now, as you know, we have these columbariums now, these post office boxes in cemetery. And that's a good way to deal with it. But other people say, I don't know, I want the ashes spread down the Gander River or something. Well, that's fine. But, a lot of people will say, and my ashes are to be dealt with as my executor deems fit.
Okay.
So that's,
and last one, I guess, a joint will. Are there complications with that, or would you recommend that both spouses have different wills?
Well, they could have the same. Both spouses have separate wills, but they're identical. They're just mutual wills are fine, except they do get a little convoluted. Trying to read them, and they don't. I never do them.
Is that right?
I never do them. I do, like, if the husband and wife comes in, I produce a draft. Once it's approved, I make two wills identical, except they reverse.
Any situation, and final question, any situation where you would say you don't need a will?
If they have nothing.
Yeah. No spouse, nobody, you're a single person alone in the world. That's probably the only
and you
reason.
have no assets.
Yeah.
There's no need to have any will. You need a will if you have assets.
That's it, yeah.
And that's essentially why you need a will. And that's simple. And even if you have assets and no will, the Intestate Succession Act will come in and make distribution according to that. A lot of people think if you die without a will, your estate goes to the Crown.
Exactly.
It doesn't happen.
Okay. Dennis, thanks very much.
Very welcome.
It's been eye-opening for me.